We shall now start off with Focus on Health Law. This is a presentation of Attorney Kenneth Haber from Maryland. To moderate this segment is Attorney Ramesh Khurana of the Khurana Law Firm, also located in Maryland. This week, Attorney Khurana questions Attorney Haber on malpractice and the doctors. This is part one of a multiple segment series. Let's join these two attorneys in their discussion.
Good morning. This is Ramesh Khurana, attorney at law from Maryland, and I'm very fortunate to present to the audience this morning Mr. Ken Haber, who is a former assistant U.S. attorney and a senior attorney in the Office of Inspector General, and at this point he is practicing in Maryland. Ken, welcome to the Capitol Forum.
Thank you, Ramesh.
Ken, this morning I am going to ask you questions about the malpractice issues which are faced by the doctors. No doctor wants to hear that he is being sued by an able attorney like you for the malpractice.
Well,
right?
They don't have to worry because I don't sue them. For
Oh, that's
malpractice.
great, that's great. So you always defend doctors whenever they have some issues.
Well, I do sue doctors, but it's for other doctors.
Okay, that's great. Good to know that. Now, when we are talking about the malpractice issues, now can you explain when do you think is the beginning of malpractice issues against the doctor and what the doctor can do to stop it if possible?
Well, the beginning of the malpractice issue is the doctor-patient relationship. The doctor-patient relationship is critical in defining malpractice because of the fact that you have a professional relationship and also a contractual relationship. It's through these two relationships, there are legal implications that will define malpractice for the doctor. The doctor has to live up to the standards expected of him in the industry and also the contract. Nothing by contract is going to eradicate the doctor's responsibility to live up to the standards, the professional standards that exist. However, that contract can define what type of relief is available to the patient, such as arbitration. You can have an arbitration clause there. Whether or not your insurance carrier would, malpractice insurance carrier would permit this or not, you'd have to check your policy. If they would, that's great, and I'll explain why. If they don't, then you can always put in a provision that if you're to be sued, it would be without jury, only by judge. You can put in a provision in your contract. Your contract with your patient can be a written contract that has these type of provisions. It can have you're being held harmless for third-party acts. It can have that if the patient fails to prevail in a suit, that the patient has to pay all your expenses, including your lost time, your attorney fees, and everything else, so that they won't just frivolously think, well, I'll just throw a suit against this doctor. Some people might say, do I want all these provisions in the contract? Well, the question is, do you want a patient who wants to sue you, who doesn't want to sign these provisions? I don't think so. You know.
Now, Ken, let me stop you here. You're talking about the contracts provision. Now, my question to you is that we all know in real life, a patient hardly has 5 minutes to look at the contract and put his name and sign it. He doesn't have the ability to consult any lawyer, like what he is signing away. He is signing for his life. Because if there is a malpractice issue that's playing with his life, and he has got the right to sue him and seek justice. But if the attorney like you has prepared a foolproof contract for the doctor, can't he challenge later on that I didn't have the benefit of having looked at the contract by an attorney, I just signed it, whether that defense is going to work against the doctor, or once the contract is signed, this is irrevocable?
Well, the fact of the matter is that whenever people are signing contracts, they're often in that same position. The doctor can have a provision in there that the patient has been given a copy of the contract to take to whoever he wants, and the patient should sign and initial that then. That way, the patient can't say, I didn't take the contract, I didn't have an opportunity. He's been given a copy of the contract, he's signed off that he's been given a copy of the contract.
That's a good observation, yes.
So long as it's not an emergency room situation,
Yes.
that patient comes back to that doctor is coming back with full knowledge that these are the underlying terms and conditions.
Now, in that connection, let me ask you one more question. You did talk about the arbitration provision in the contract, and you did say unless it is prohibited by the insurance companies or other regulatory authority. Now, let me ask you this question from the licensing board point of view. Whether do they permit arbitration provision? Do they look at it favorably or unfavorably, or they are just silent about it?
I have not heard of any licensing board refusing a doctor having that type of provision. The federal government has a statute specifically endorsing arbitration. The courts indeed endorse the arbitration provisions by enforcing them and refusing, unless there's fraud involved, to negate the arbitration provisions. Arbitration has become recognized more and more within the society as a viable alternative to litigation. And the fact of the matter is if the malpractice company has some provision that doesn't, for whatever reason, want to accept arbitration as a means of resolving disputes between the patient and the doctor, then the doctor certainly can have a provision where the patient has a right to a court, but only the judge can waive the jury trial. There's nothing that says that people can't make waivers such as that either. That would be pretty difficult for the malpractice carrier to object to it. I have not done a survey of malpractice carriers. I do know that some insurance companies don't like arbitration for whatever reason. But the fact of the matter is I would think that they should view it favorably because of the fact it cuts down their exposure dramatically.
Okay. So when we are talking about a forum away from the court system and we are talking about the arbitration, could it be a mediation also, or mediation is prohibited?
Mediation generally is not a binding type of resolution.
But it's less expensive.
It's less expensive. Maryland has a mediation process right within its malpractice system. If I was going to write a contract for a doctor, I would check to see what his malpractice carrier provision provides for, and if it would permit the arbitration, I would certainly put that in. And go for that, and put down that if that was struck down, then it should be a trial by judge without a jury.
Now, another important issue here is about the insurance policy, which you have mentioned in your response to the questions. Now, we know that in real life, doctors do apply for the insurance, malpractice insurance. When the policy comes back to the office, I don't think most of our doctors have time to read them. Even if somebody wants to read the provisions of the insurance policies, now what are the highlights or important points which a doctor should be aware to pay proper attention to them?
They should be aware of whether or not the policy limits are inside or outside of the defense costs. What you want is defense costs outside of the policy limits. This leaves the greatest amount to pay off a judgment and also leaves the greatest amount to settle a case if the costs of defense are outside the policy limits. This policy could cost you extra, but the fact of the matter is that it might be well worth your while, depending upon what that extra cost is. You want to have a provision that the insurance company cannot force you to settle a suit. They want to be able to settle a suit. It costs them a lot less than going to all the way, because of the fact even if they settle the suit for policy limits, they're avoiding all the costs of litigation.
But at the same time, insurance company would most likely increase the insurance premium for that doctor if they settle it, and doctor is not interested in settling it down.
The doctor's not interested. If
Right.
the doctor knows what's good for him, he won't settle, because of the fact that he's going to be reported to the licensing board.
Yes.
And in addition to that, he'll have to self-report to the different entities that he's seeking privileges at or with. And it's a terrible situation when he's forced to settle.
So what you are recommending here is that doctor should make sure while obtaining an insurance policy that he has the authority to give his opinion or concurrence for settling the case.
That's correct, and an ability to refuse to settle the case.
Okay.
I had a case
Got it.
once where the doctor did not have that right, but we got together telephonically with the doctor, the insurance carrier, their representative, and the defense attorneys themselves, and made it quite clear that the doctor was at risk here for some real harm if they were to settle the case, and that they had an obligation to do discovery and see what else can come up. When they started their discovery, the defendant, not the defendant, but the plaintiff's attorney withdrew from the case because they figured it was just going to be an easy squeeze. It wasn't an easy squeeze. They didn't want to work. The plaintiff's attorneys didn't want to work. They withdrew from the case when they saw how terrible the case was against the doctor. The doctor did nothing. And the fact of the matter is that the case fell apart at the jailhouse, not the jailhouse, at the courthouse doors, because there was no attorneys to go forward. And it was because the doctor took the time to hire somebody to get involved that created an incentive for the insurance company, even though they had a right to settle. We were discussing the fact that they settled without making a good faith effort to protect the doctor, that we would claim that they were operating in bad faith on the contract. They didn't want to find out whether that theory would prevail or not, so they decided at least give the discovery, and everything fell apart on the other side by the time that was done.
Now Ken, we are running out of time, but if you can answer quickly about the question of hiring insurance company paid attorney, because there is a potential conflict of interest. That attorney wants to continue to be on the panel of insurance company. What a doctor can do about it?
Not much, unless the doctor's contract provides for selecting your own attorney. That's the attorney you're going to be stuck with, because the policy provides for that. It creates a conflict, but it's a conflict that's been accepted within the system for as long as the system's been in existence. So what a doctor can do is to hire an attorney that they trust and get advice from that attorney.
Very good. Good advice to the doctors by Ken, that you have got to look at the provisions, and it would be better if you have them looked by your competent attorney who understands whether these provisions are going to be helpful to you, especially when you have an allegation of malpractice. So with these words, I would like to thank you very much, Ken.
Thank you.
For coming to the Capital Forum and
My
answering my questions about the malpractice issues which are faced by physicians who form a significant portion of this audience. And I would just advise you, please talk to your competent lawyer if you have any issues. Again, thank you very much for being with us this morning.